right, I want to welcome you to our fair housing program this morning, and I think you should be able to see our agenda on the schedule in the webinar. I'm going to start off with Warren Duncan. He's the director reporting and compliance for Detroit's HRD Housing and Revitalization Department, and he's going to kick us off. Mr. Duncan.
All right. Good morning. Good morning, everyone. Glad everyone was able to join this fair housing webinar. Again, my name is Warren T. Duncan. I am the Director of Reporting and Compliance of the Grants Management Section of Housing and Revitalization Department, HRD. On my team, we have Marlene Robinson is here and Jennifer Mahone. On behalf of the department, we are happy to present to you today the Fair Housing Center of Metropolitan Detroit to give you a very informative presentation on fair housing awareness and a new ordinance for the city of Detroit residents. Just a brief synopsis of what our department does. The Housing Revitalization Department sustains and grows neighborhoods that are inclusive of quality, affordable housing opportunities for all Detroit residents and economic opportunities through grants management of federal housing, community development funding, steering local housing policy, maintaining and creating mixed income and mixed use housing opportunities through transformational developments by leveraging public and private partnerships. In other words, we are here to benefit and support the city of Detroit community residents and to ensure access to decent and affordable housing options in thriving neighborhoods across the city. You can go to our website at www.detroitmi.gov, and you can see all kinds of assistance as far as home repair, if you're having problems, evictions, things like that. You can go on our website and you can get assistance. Again, that website is www.detroitmi.gov. I'm sorry, and you want to put /HRD. If you put /HRD, it go directly to our department. Okay, with that said, I'm going to turn it back over to Steve, Executive Director of the Fair Housing Center of Metropolitan Detroit. Steve, you can take it back.
Good morning, everyone. My name is Lesa Kent. I'm from the Civil Rights Inclusion Opportunity Department, also known as CREO. And so today I'll be talking about the Fair Chance Ordinance. Thank you, Steve, for having me today. I mean, it's really an honor to be able to discuss the Fair Chance Ordinance. This legislation was brought to us by the Honorable Counsel Member at Large, Shanae Ayers. She indicated that, you know, when prisoners return, they often have nowhere to go. And so it's important that we have opportunities for them to be able to have housing and not have any barriers with that housing. So this ordinance is to reduce that and to help with second chance citizens. So what I'll be talking about today is the Fair Chance Ordinance, who's impacted, how's it impacted, and how this can be an opportunity for everyone to have housing. So who's impacted? So the Fair Chance Ordinance ensures that second chance citizens have a fair opportunity to be able to secure housing by regulating the use of criminal records. Steve talked about criminal records, and this is the use of criminal background checks. As we know, when we talk about housing, that's one of the factors that landlords use. So who are the people that are impacted? Unfortunately, second chance citizens are disproportionately members of the minority groups. They're typically poor, homeless, and often report no or very few connections to any family or close friends that they can go to when returning to the city of Detroit area. So we talk about housing barriers. So what are some of the housing barriers? So individuals who are released from prison and jails, they need access to safe and secure, affordable housing. That's just a given. So this ordinance is critical, is very to their successful reentry into the general public. Many formerly incarcerated individuals they encounter significant barriers securing housing, including public and federally subsidized housing, and because of their criminal records. So even individuals who were arrested but not convicted, they face difficulty securing housing. Unfortunately, African Americans and Hispanics are arrested, convicted, and incarcerated at rates disproportionate to the share of the general population. In the next few slides, we'll talk about that. So criminal records based barriers to housing are likely to have disproportionate impact on primarily minorities. So here's a couple of statistics that talks about that. Over 100 million US adults, up to 1/3 of population, actually have criminal records. US prison population exceeds 2.2 million, which is the largest in the world. And US accounts for 5% of the world's population, yet it's 1/4 of the world's prisoners. So we have a large prison population. Since 2014, over 650,000 individuals are released annually from prison. And over 95% of the current inmates will be released at some point. So because of this, we need to make sure that there are no barriers to them receiving any housing. So while the housing barriers are due to criminal records, we see that this disproportionately affects minorities. We see in this particular slide, it's 1 in 27 who may have been, has a correction, and then 1 in 11 for African Americans. These are high statistics. As we see, for our white counterparts, it's 1 in 45. So in 2014, Blacks comprised about 12% of the population, but 36% of the total US prison population. Blacks are incarcerated at a rate nearly 3 times their proportion to the general population. Hispanics comprise about 17% of the population, but approximately 22% of the total prison population. So we see with these numbers how this affects the Black and Brown community more than any others. So now let's talk about the ordinance, okay? How this ordinance can help alleviate some of those barriers. So Detroit was among the first cities nationwide to adopt the Fairchest Ordinance. It primarily applies to single structures of 4 or more dwelling units, or landlord or property owners that have 4 or more rental properties that are owned by the same person. It prohibits consideration of criminal records until housing providers first determine the applicant's qualifications. We'll talk a little bit more about that. It grants an applicant the opportunity to present evidence of rehabilitation or mitigating factors. So even if you do have a criminal record, you can be able to provide some rehabilitation information or mitigating factors to give to the landlord to consider. It requires individual assessment. It's not an overall review period. And then it provides detailed guidance when the application is denied. What happens next? So now we're going to talk and break down each part of the process. So of course we want to know, who does it apply to? So the Fairchest applies only to the landlords, like I said before, with 4 or more dwellings or 4 or more rental properties owned by the same person. And the ordinance applies to potential tenants that have been arrested or have a criminal record. So how does it work? So first, a potential tenant applicant applies for housing. Their eligibility is determined by their credit history, leasing history, and other similar factors like how long they've been on the job, things of that nature. After being reviewed and a determination is made that the potential tenant will be offered a conditional lease. So this conditional lease is offered before the housing provider knows anything about the person's arrest record or conviction record. So basically, the determination of whether or not I'm eligible for this particular housing is made on factors such as credit, how long I've been on the job, my leasing record, and then I'm given a conditional lease. Once we're offered a conditional lease, the landlord may then investigate the criminal history. So the conditional lease, basically the condition is, here's your lease unless I find something on your criminal record that can prevent you from receiving the housing. So we're going to talk about what things are considered as far as on the criminal record. So if the applicant has a criminal record, they may be denied housing only for crimes relevant to the safety of other people or property, like violent crimes, crimes resulting in a lifetime registry on the sex offenders list, arson, or for felonies committed within the last 10 years or resulting in a prison within the last 5 years. Okay. So what are the next steps after that? So I'm an applicant, I'm a landlord. What happens next? So if the landlord wants to deny an applicant based on their criminal history, the landlord must allow the applicant to provide evidence of rehabilitation that will show that they are a good candidate despite their criminal record. I might have a criminal record before, but now I've turned my life around. I'm an asset to the community, and I would like to have rent in this particular property. If the applicant feels they've been discriminated against under that ordinance, they will have the right to file a complaint with our department, the City of Detroit's Civil Rights Inclusion Opportunity Department, CREO. The department will then investigate. We have investigators on our team, they do an investigation, and if a violation is found, the Detroit Police Department will issue a ticket to the landlord for a misdemeanor that will be taken up by the 36th District Court. Okay. So I'm kind of used to saying, are there any questions next? So let me continue on. These are the things that the housing provider may not ask. Have you ever been arrested? Have you ever been convicted of a non-criminal offense? Do you have a criminal record? Do you have any misdemeanors? Have you ever been convicted of a felony? These are things that they cannot ask. These are the things that they must do. So this notice must be posted in solicitation or advertisement for rental or lease property. I know that this notice is being posted because we've received calls in our department about this notice. On the website, you might see the notice that says the rental or lease of this property must comply with the City of Detroit's ordinance regulating the use of criminal backgrounds as part of the tenant screening process to provide citizens with criminal backgrounds a fair opportunity. For additional information, please contact the City of Detroit Office of Civil Rights Inclusion and Opportunity. This notice must be on any solicitation or advertisement for rental or lease property. This is another must the housing provider must do. If the housing provider intends to deny housing based on the conviction, they must provide the applicant with a copy of the background check. Basically, what did they make the determination that they're going to deny their housing on? And then within 14 days, applicant must notify the housing provider of any inaccuracy. And the housing provider must then delay the action. That means not rent the rental property for no less than 5 days after receipt of updated information, and may reconsider in light of the updated information that they received from the potential tenant. All right, so I said before I was going to talk about reasons of why the application can be denied. So here are the reasons. They're ineligible for public housing, period. Lifetime sex offenders, violent or drug-related felonies, felonies committed within the last 10 years, imprisonment in the last 5 years, crimes against landlords, management, employees, agents, tenants, arson, metal theft, vandalism, and real property damage. Those are the reasons to deny. And these are the reasons not to deny. Arrest that didn't result in a conviction, participation or completion of a diversion or deferral judgment program, a juvenile record, a misdemeanor conviction that's over 5 years old, and information regarding other violations such as civil infractions or convictions that have been expunged or invalidated by court or pardon. So even with that denial, you can still allow the applicant to be able to provide proof of rehabilitation. And so what does some of the rehabilitation look like? A letter from their employer, school, counselor, parole, probation officer, completed community service, compliance with all terms and conditions of the parole, employer recommendations, especially post-conviction, educational or vocational training included, rehabilitation treatment. These are things that can provide proof of rehabilitation and give mitigating factors to the landlord or why you should still be able to rent the property. So of course you want to know, okay, I've filed a complaint. And so how does that, what happens once I file a complaint? And so now I'm going to discuss like what the process is after you file a complaint. The complaint is received several ways. You can either send online, it's a paper copy that's available at the office, you can email a copy or you can phone in. I'm going to show you after I complete the presentation where on the website you can go to make the complaint. So after we receive the complaint, we do an initial assessment. We got to figure out, okay, is this something that we will really investigate? So is the housing within the city of Detroit limits? Does this landlord have 5 or more units? And then we talk about adverse action. So that means adverse action had to happen to the tenant. Were they denied or were they evicted? The notification ordinance was not provided. Communication indicating that persons with arrest could not be considered. Inquiry of the conviction record prior to deeming eligible. Housing provider did not give notice of reasons of denial. The housing provider did not offer a chance to provide evidence of inaccuracies or rehabilitation. So this would trigger an investigation. These are the items that will trigger an investigation. Also, we got to know that the violation complaint is with 60 days of the occurrence of the alleged violation. So basically 60 days, keep saying 16, 60 days within being denied application or evicted or any of those other items listed as an adverse action. Also part of the process is you give notice of the alleged violation. So the complainant and respondent receives notice from the investigator, and then the investigator has an investigative plan, which they request documents, they witness, they interviews, and they have subpoena power to be able to get these documents. A determination is made by the director, and then when there has been a determination that there's a violation, the warnings are issued. A second violation refers determination to an enforcing agency for action. And then as we talked, the DPD is the enforcing agency and they take action and based on determination made by the administrative department director. All right, so the next thing we want to talk about is contact information. Like how do you get in contact if you have any of these concerns or questions about it? You contact myself, Lesa Kent. There's my phone number, their email address. And so the complaint is, this is the short version, it's the bit.ly, it's bit.ly Creole complaint, and the Creole email is creole@detroitmi.gov. So now I want to go to the website so I can show you where you can make your complaint at. One moment. Okay. So can everyone see the screen where it says City of Detroit website?
I see it.
Okay, great. So you go to departments, go down to Creo. You go to file a complaint. So what you will select is submit a complaint. I am not a City of Detroit employee. You will select that. And then you will answer this question. Did this discrimination happen in the City of Detroit? Yes. You complete the form. Your name, the respondent is the person or the agency that you're renting from. You answer these questions, and then here's the part. It says, what is the area of your complaint? You want to make sure you select housing. And then the next question is housing citizens with arrest and conviction records. You select that. And that will be considered what we understand as a fair chance housing complaint. And then you complete the rest of the form, hit submit, and we will receive the complaint, and you will receive contact from one of the investigators within 48 hours. That's all I have. If there are any questions, I look forward to answering all the questions that you may have. Thank you again, Steve, for having me here to be able to share about.
You're not going to get away. You're not going to get away that quick without answering some questions we have.
Okay.
First one, Matt, is the conditional application similar to the actual application? Also, what if there's a question on the conditional application about criminal background? Does the prospective tenant ignore the question? If so, will that potentially cause him or her to be denied housing?
Right. And so conditional, it should be a conditional lease. Now, conditional, there should not be a question of criminal record on the application. And you not answering that question should not be a reason for denial. Period.
Okay. And I think we talked about this before the conference, in that your office doesn't have an example of a conditional application, correct?
It's actually a conditional lease. And so,
conditional lease, rather, I'm sorry. Yeah,
so basically what this conditional lease, it says, I met all the eligibility factors, and I can get this apartment or place or housing. The next step and the final step is the criminal record. And so I have a lease in hand, but it's a clause in there that basically says it's conditional based on the background check, my criminal background check. And so once they receive the background check, then I'm able to move into my apartment because I have the lease. It's not the actual application, it is the lease to allow you to move into the apartment.
Okay. I didn't realize that you have to get the complaint in within 60 days. That seems very tight.
Yeah, 60 days of me being, so like if I've been denied, I have 2 months to be able to let someone from Creo know that I've been denied. And like I said, it's a phone call can start the process. And so, you don't necessarily have to know where to go to the website, because once you give that phone call, then you've indicated that, the adverse action has happened. And so at that point, we start the complaint process.
Right. And then in terms of first of all, are the contact, would that become a public record or is it confidential?
Say that at one part again.
Well, people they're reluctant to share it with you because they don't want their criminal record, whatever it is, to be made public. Is this kept confidential when they make a complaint?
Yes.
And then what kind of information does someone give if the evidence of rehabilitation or other mitigating factors?
Some of the things like we talked about, vocational training. I've been gainfully employed. I volunteer in the community. Things of that nature to show that you have been rehabilitated, that your criminal past is not your present. And so things of that nature will be considered things as mitigating factors.
So it's not, there's no real restriction on the kind of information that you can provide.
No. It's anything that you think that will assist the landlord in saying, okay, despite this person's criminal record, I will, consider them for being able to rent my home. Say, for example, you had a criminal record that's, just past the 10 years. And so for the last 9.5 years, you've been gainfully employed, doing well in the community. That should not be held against you as a result of something that happened, just shy of the 10 years.
Okay, and then we received another question. It says, I'm interested in renting to returning citizens. Is there a program that would connect me to returning citizens that need housing?
Wow. I'm not aware of one, but I'll still like to get your contact information, because a lot of times when we have these seminars or programs, people who want to get housing, they don't know where to look. And so, yes, we would definitely like that information so that we can be able to provide that to people who are seeking the housing.
I know there are a number of organizations that are looking to place people, and they have difficulty because of criminal record, and there is sadly, right, a large degree of non-compliance. Another question, if the prospective tenant does not know about the ordinance in Detroit and gets denied housing, how is the landlord held responsible in enforcing the ordinance?
It's not the tenant's responsibility, it's the landlord's responsibility as well. Maybe I didn't understand the question.
If the tenant doesn't know about the ordinance and gets denied housing, apparently because of a criminal record,
okay.
How would the landlord be held responsible? I suppose someone would need to make a complaint. Really.
Yeah, we would have to know for us to be able to take any action.
I do know that our office could send, and we send out testers posing as people with a criminal record and to see the answers that housing providers give. So that's one way that we assist with that process. So we send testers or checkers out to do that. And this is a shameless plug for people who would be interested in being a tester for us. Please contact us. It's on our website. Consider that. We got another comment. I'd like to connect with that person. I'm a probation officer and housing is a need. That's ccinvesting@gmail.com. Thank you so much, CDE Capital. Ms. Mixon, I think that would be a good reference for you to use. That's excellent. Another question, what is the turnaround time after making a complaint to ensure that an individual will receive housing after they were denied? I think that's asking, what's the approximate time frame for your office to process a complaint?
And we have to process it within 60 days.
Oh, that's pretty quick. Okay, and then if someone did that complaint process and say you found a violation, could it result in the person then being given housing or granted housing? Is that some of the things that you could do once a complaint comes in?
Say that one more time.
If someone, say you find that there has been a violation, can then you have the landlord reconsider the application and then perhaps rent to the person?
Yes, that the complaints that we have received so far, that's generally what happens. Once we, first of all, a lot of times the landlords do not know about the ordinance. And so once they're made aware of the ordinance, they generally, they want to comply. And so once they made aware of the ordinance and that person provides rehabilitation or any documents in that regard, they're able to get the housing.
That's great. Another questions are coming in. Do all landlords, property management companies know about the ordinance?
No, unfortunately. That's why we have seminars like this. We post it on Facebook. We try to provide it to social media. The departments know about it. But unfortunately, not all of the landlords know about it.
Here's another question. Do you assist prospective tenants who are registered sex offenders?
No, that's one of the things that it could be denied as far as an application. When you mean assist, what do you mean?
I'm not sure. That's the way it says. I guess maybe if there's any programs out there that can assist or provide help to prospective tenants who are registered sex offenders but have been unable to find housing.
Yeah, I'm not familiar with any of those programs. But just like any other things that are denied, if there are some mitigating factors that are provided, those will be considered as well.
Yeah, and I think that you went through on your presentation, which is great as it always is. But you mentioned that the factors, like one of them was any conviction for violent or drug-related felonies, or any conviction that leads to the applicant becoming a lifetime registered sex offender. These are grounds that would permit a housing provider to turn somebody down, right?
Yeah, those are things to deny, but it does not prevent. What I mean by that, they're still allowed the opportunity to provide factors that might mitigate or show that they have been rehabilitated despite those criminal convictions.
So, for example, if they're a registered sex offender, that could happen when they're 20 and they're now 50 with no other record since that time. Something like that.
That's a perfect example.
This is a little bit off the subject, but I think it's a good one though. Are any Detroit fair housing agencies advocating for lawful source of income, anti-discrimination ordinance? Many low-income renters are being locked out of housing using Section 8 vouchers and other local and temporary rental assistance vouchers.
Now, that's out of my purview. I'm not familiar with that as far as programs that are available. Maybe someone from the Housing Revitalization might know about it.
But the Detroit ordinance for housing does cover public benefit status, correct?
Oh yeah, for sure.
What is public benefit? Here's what
Okay.
what we're seeing. I'm working with Oakland County in proposed ordinance that other cities, villages, and townships within Oakland County, encouraging them to adopt source of income protection, also to make people accept Section 8 vouchers. It's a real problem. The vouchers aren't that helpful when there's a shortage of housing and other housing providers aren't accepting it. So anyways, we've gone through and we found a lot of cities, states that have adopted source of income, but Detroit doesn't get listed, even though public benefit status is a lot like source of income, maybe even broader, but Detroit's not using the magic words, public source of income. That's a concern that I have. So maybe Detroit has to say add source of income expressly to the ordinance, and maybe that will make it clear to people.
Right.
But if there's a complaint concerning public benefit status, that they would be directed to CREO. Would that be correct?
Right. So that is considered a protected class under the city code, city ordinance, chapter 23 of human rights. That's considered a protected class that you can be discriminated against, public benefit status. So we receive those complaints. If people are denied, a lot of them are in regards to housing, people are denied housing based on, we've gotten based on being on unemployment. So yeah, those are complaints that we investigate.
And then, but that's a good question about source of income. It is a major barrier to people, along with criminal record. Another question, they're coming. What if the property owner only owns 1 or 2 rental properties? How is it applicable then?
Yeah, unfortunately, the ordinance is not applicable if they only own 1 or 2. But what we find is that it's very few property owners that own 1 or 2 that are not compliant with the ordinance. Majority of the complaints that we get are from property owners that fall under the ordinance.
And what happens if an individual does not have an advocate to speak or confirm their rehabilitation? What would they do if they don't have anybody to speak to their rehabilitation?
Provide any documentation that they might have, a certificate, a letter or recommendation from your pastor, from your the person who you currently work for. You know, this employee comes to work on time every day. He's a asset to the program, he or she. Things of that nature shows a landlord that, okay, if he's, you know, responsible to go to, he or she responsible to go to work every day, then that shows that they can be responsible where they lay their hair at. So those are things that a landlord will consider.
This was a little bit off subject. We're gonna, Ms. Kelly's question about work and rehabilitation, we're gonna answer that when we come to the latter part of the program. Where do we find, I'm not sure how to answer this one. Where do we find the criteria list for approval? I think they're asking, you have the list of factors that would, I guess, permit someone to be turned down. Doesn't require it, but may permit it. Where would they get that list? It's in the ordinance. Is there another place where people can get that list?
Yeah, it's in ordinance. And then, Steve, I will, you know, of course, give you this PowerPoint presentation so you can have it available on your website. And, you know, if they contact the city of Detroit, they can get the list. But so the factors that are considered besides the criminal record, those are determined by the landlord. Like I said, how long you've been on the job, your past leasing history, those are factors that are given by the landlord. But none of those factors can be discriminatory. So it can't be, you know, how many people are in your family, what your race is. Those things can't be considered.
Correct. Does this apply to property management companies?
Yes, most definitely.
Yeah. This one about, we need affordable housing right now versus years down the road when we have proven ourselves. Where is the provision under this ordinance for those of us who have a recent conviction?
It applies for people who have recent convictions as well.
Yeah, this doesn't put a time frame except for felonies over the last 10 years with imprisonment, or imprisonment for felonies in the last 10 years. Right, so there is some, but the other ones, it doesn't necessarily categorically exclude you, does it? Even if a recent conviction doesn't necessarily exclude someone, does it?
No, not at all.
All right, I appreciate that. Oh, I want to say, you've given us a couple other informational sheets. You gave us kind of a flow chart or infographic.
Yes.
That's on our website, and it's very, very helpful. And then you also did 2 other things, information for tenants and information for landlords, that are both very informative.
Yes, those are on our website as well. Under Fair Chance Ordinance. If you put in the search bar Fair Chance Ordinance, both those items will pop up. The infographic as well as the it's a double-sided document that we like to get out to all the property owners so that they can have at their facility or site. One side is for the property owner and the other side is for the potential tenant, and kind of just breaks down the whole ordinance so each person knows what rights they have under the ordinance.
That's terrific. Thanks. Really appreciate all the work that you or your office has done to get the word out on the Fairchest Ordinance. No better compliment to see that it's now been copied in Jackson and perhaps other cities to follow. Another question, is there any hope for persons with evictions in their path? Sometimes convictions contribute to evictions. That's so true. What should we do, or where do we go for help? That's a challenge, isn't
Yeah,
it?
that unfortunately evictions is a challenge. That's all I can say. It's a challenge. I mean, because those are things that landlords take a look at, you know.
Yeah, it's unfortunate. But that's something that we will have to give a lot of consideration to, right? There may be many circumstances why someone has an eviction case filed against them or is evicted, and that's something that should be considered. But the ordinance only deals with criminal records with the evidence of mitigation. I think you would have to do that informally on your own to kind of explain your past eviction and the circumstances. Thank you so much, Lisa. I don't know if you're able to stay on if additional questions come up. My presentation will kind of overlap with yours. Oh, great. See if I can share my screen here. Let's see. I may need to restart. Let me try here. Okay, I think I'm able to share it here. Okay, I don't think everybody can see it okay? Let me know in the chat. And this is really, it piggybacks on what Lisa said. First off, this is dealing with fair housing violations and the misuse of criminal records. The Detroit Fair Chance Ordinance applies to Detroit, and it applies to covered properties of 5 units or more, and that they have to comply with, under the ordinance. In a broader context, stepping back from that, it also, all criminal use of criminal records raises fair housing issues. The key guidance on this, HUD Office of General Counsel issued guidance in April 2016 and how the Fair Housing Act standards apply to the use of criminal records. While the guidance is not binding on courts, courts have looked at that guidance, found it helpful, and have found liability under the Fair Housing Act against housing providers and management companies. So here's, under the Fair Housing Act, there's 7 protected class categories. We like to use fresh corn, first one being race, second color, religion, national origin is the 4th category, sex is the 5th, then the last 2 are handicap, which the modern term would be disability, and familial status, discrimination against families with children. And it makes the E for equal housing. It doesn't specifically cover, criminal record is not a protected class category. It doesn't make anybody with a criminal record part of a new protected class. And there's nothing in the Fair Housing Act itself that prohibits housing providers, landlords, others from considering criminal records when making housing decisions. And the Fair Housing Act applies to a wide range of housing decisions, including screening for rental decisions, evictions, non-renewals. It applies to all housing, both in the public housing or finance housing, finance housing, as well as the private housing market. It also applies to public housing authorities, and it applies to housing, for example, housing for older persons would be covered as well. And so It does prohibit housing providers from using arrest records alone as a basis for a housing decision. But what it does do is it prohibits blanket, broad-based housing policies based on criminal records. For example, we don't rent anybody with a felony, or we don't rent anybody with a felony in the last 20 years. That would be very, very problematic. It also does prohibit housing providers from using criminal record as a pretext, cover up for what the real discrimination is in a way that has an unjustified burden on a protected class. Here's the two theories, legal theories of proof when it comes to fair housing violations, the two main ones. One is disparate treatment, the other is disparate impact. It's important to distinguish the two when it comes to discrimination in the use of criminal records. Discriminatory treatment, a defendant has a discriminatory intent or motive. Disparate impact, it's a facially neutral policy or practice, but it has a disproportionate adverse effect on a protected class, and it's not otherwise justified by a legitimate rationale. It's easier to look at in terms of specifics rather than dealing with it kind of in the abstract. Well, here's the disparate treatment, and this is the HUD OGC Council guidance. Here's three examples of what would be discrimination in use of criminal records based on disparate treatment, theory of liability. First one is a housing provider rejected a Hispanic applicant based on his criminal record, but admitted non-Hispanic white applicant with a comparable criminal record. Here you have two people being treated differently. The only difference between them is protected class status. That would be a violation. Or I could say a housing provider rejected a black applicant based on criminal record, but then rented to a non-black or white applicant with the same or similar criminal record. That would be a violation. That's disparate treatment. Well, here one, housing provider has a policy of not renting to persons with certain types of convictions, but then makes exceptions for whites, but not for African Americans. That would be disparate treatment. Different people based on protected class status are being treated differently or disparately. Last one, leasing agent assists a white applicant seeking to secure approval of his rental application despite a potentially disqualifying criminal record, but then assisted, right? Trying to here's what you need to say in order to get approved. But then when a black applicant came in, no such assistance provided. That would be a violation. If treating people differently. Disparate impact is a little bit different, where it's a facially neutral policy, which in application has an adverse impact or discriminatory effect on a protected class category. And notice too, here it says not motivated by discriminatory intent. There may be a discriminatory intent, but it's not required to be proved. All it has to show is that it's a neutral policy that has an adverse impact on a protected class. And here's always involves 3 steps. You have to show that the policy has a disparate impact on a protected class using some kind of data, either national or local or national. You want to drill down to the most applicable, like we will use, for example, Michigan data, statewide data, or county data, city data if it's available. And then if it shows that the policy has an adverse impact on a protected class group, then the housing provider must show that there's a legitimate justification for that policy. When it comes to criminal record, the housing provider probably says, well, we're concerned about safety. We're concerned about safety to our staff. We're concerned about safety to other tenants. We're concerned about any damage to the property, okay? And so if someone has a felony for writing a bad check 5 years ago, is that going to be a problem in terms of a threat to other persons? Probably not. Is that going to be a threat to property, damage of property? Probably not, right? So you can't just do a blanket one. There have to be some reason why they have the policy in place. No stereotypes or assumptions are permitted. And then the tenant or the applicant must then show that there's a less discriminatory alternative to accomplishing the same goals of protecting resident safety and property other than the policy that currently exists. Let's go to, Lesa gave some of the statistics. I'm not going to repeat them, but there are housing barriers. She gave the numbers, the number of people that have been incarcerated in this country, staggering. Then when they're finally released back into society, they've been excluded from employment, housing, all kinds of various parts of life because of a criminal record. They need to be brought back into society. African-American Hispanics are incarcerated, arrested, convicted, incarcerated at rates far higher than the general population. So what would otherwise be neutral criminal record policies will have an adverse impact on Black and Hispanic applicants. In our part of the state, or within Detroit, we don't have that issue when it comes to Hispanic population. In other parts of the country, other parts of Michigan, there's a higher Hispanic population and it would have an adverse impact on them. Within the Detroit community, race is the factor that gives rise to the disparate impact. And here's why. In one of our cases, we came up and found this study. And the study says we estimate that 3% of the total US population and 15% of the African-American adult male population has ever been to prison. People with felony convictions account for 8% of all adults and 33% of the African-American adult male population. So what happens is if there's a policy, for example, let's use the same example, anybody with a felony in the last 10 years, we won't rent to. Or anybody with a felony or misdemeanor conviction in the last 10 years, we won't rent to. When that policy is neutral, it doesn't say anything about anybody's race, ethnicity, religion, it doesn't say anything like that. It's just a facially neutral policy. It's not discriminatory on its face. If you're turning down anybody with a felony or anybody with a felony or misdemeanor in the last 10 years, that policy by a housing provider is going to end up disproportionately excluding African-American adults. It's also going to disproportionately exclude African-American males, just by virtue of the policy and the statistics. So they will have to recalibrate that policy, but a flat, no felony or misdemeanor in the last 10 years would be a violation of the Fair Housing Act. That's illegal. So what do they have to do? Again, what I mentioned, this is from the Office of General Counsel guidance. The blanket ban will not satisfy the housing provider's requirement to show that the policy is necessary to achieve a substantial, legitimate, and non-discriminatory interest. Blanket bans don't cover it. And when I say fair housing, just so it's clear, Office of General Counsel relied on employment cases under Title VII where violations were found under similar facts. If an employer says, well, we're not going to hire anybody who has a felony in the last 10 years or a felony or misdemeanor conviction in the last 10 years, that would be a violation of Title VII of the Civil Rights Act when it comes to employment. It will also be a violation of the Fair Housing Act, right? In other words, it's not, you just can't have a blanket ban. That's not meeting the real need. Housing providers must calibrate it to see if the person today presents a significant risk or not. If they don't present the risk, then you should not be excluding them. Again, Title VII shows the blanket bans there. Even with a more tailored policy that just excludes only people with certain types of convictions, still may not suffice. The policy has to distinguish between those individuals who present a demonstrable risk today of damage to property or risk of injury or threats to other tenants or housing providers or owners, as opposed to those who do not. Here, insufficient policy failed to consider the nature and severity of an individual's conviction. Studies have shown that over time, and it's a very short period of time, 3, 4, 5 years, if a person does not pick up another felony after, I don't have the actual states, I believe at least within 5 years, they're no more likely than the general public to pick up another felony conviction. It just, once people turn away from crime, they tend to stay away from crime. And those that are in it tend to stay in it. That's just the way it is. But after so many years, people have reestablished their lives, they're working, they're just not involved in criminal activity. So that must be considered. Acceptable policies do not take into consideration arrest records. You cannot consider those. Arrest records don't count, only convictions. And then you have to take into consideration, the factors that Lesa pointed to, the mitigating factors, facts and circumstances surrounding the criminal conduct. Someone may have just gone, been in the car with someone else who went and did the crime and came back and drove off. They may have had very little involvement in it, or they may have been very involved in it. That would factor into the consideration. You want to look at the age of the individual at the time of the conduct and evidence of what they've done before and after the conviction. And again, evidence of rehabilitation efforts. This is not only good practices, it's required under Detroit's Fairchest Ordinance. This is also required under the Fair Housing Act. If someone violates Detroit's ordinance, they probably violated the Fair Housing Act as well. It is also for housing, for public housing agencies, they have additional requirements. They have due process requirements. If they're turning somebody down based on a criminal record, they have to give the person notice. They've got to provide notice to the person and give them an opportunity to request an informal hearing or review after the denial, and give people an opportunity to provide evidence of that they've been rehabilitated. If they don't do it, that's a due process violation, in addition to a fair housing violation. Here's a couple example, 2 quick case studies, Jackson versus Iron Park. At the time of application, Mr. Jackson met all the requirement. He was told he had no prior evictions and did not have, his credit history was fine. He was informed that he was not approved due to a felony on his record, that he could make an appointment for an interview. He asked for an appeal. He told him they would be looked into, but they never returned his call. They never granted, he's never got an appeal. No one ever met with him regarding his application. So he filed a lawsuit saying policies and practices have a disparate impact on the basis of race or color, because evidence shows that nationally and New York State blanket bans on eligibility based on criminal history result in denial of housing opportunities at disproportionate rates for African Americans and minorities. That was it. And the court said states a valid claim under the Fair Housing Act, and he was allowed to proceed with his case to go forward to trial. That's all that's required. So anytime you get turned down for a criminal record and you think, if it's a public housing agency, you don't get an opportunity, or even in a private situation and they haven't given you that information and allowed you to provide mitigating circumstances, that becomes very suspect. You need to make a fair housing complaint. There's another case, which is important because many of the housing providers use Crim Check and Crim Safe. Says that Crim Check gives housing providers copies of criminal records to interpret on their own. Crim Safe uses an algorithm to interpret their criminal history, criminal record, and provide housing providers with a decision on whether the applicant qualifies for housing. So who's making the decision? Is it the housing provider or CoreLogic under Crim Check and Crim Safe? Well, actually, it's CoreLogic. So CoreLogic, they brought the case against CrimLogic. And so report found that the Crim Check and Crim Safe report does a screen, gives a 1-page report indicating whether disqualifying records are found. The report provides no additional information such as what? The underlying records, the nature of the alleged crime, the date of the offense, and the outcome of the case, if any. That's problematic, right? And here, Mr. Aurora was unable to speak for himself. He had an injury. He was arrested in 2014, but he was never convicted. So they said Win Residential was the housing provider. They said, we don't know anything about it. They just relied on the Crim Safe, Crim Check records. Turned out, right, there was no conviction. It should not have been considered. He should not have been turned down for housing. He actually had an injury in 2015, is unable to speak or care for himself. The man is not a threat to anybody. So he should not have been turned down. And so therefore, it's what? It's a violation under the Fair Housing Act. Because they considered the records from CrimSafe and CrimCheck and did not take an individualized determination as to whether Mr. Aurora had been convicted, which he wasn't, whether he was a threat, which he certainly couldn't be because of his physical disability, they violated the Fair Housing Act. That's how it can work. Lesa, obviously, I'm not going to go through the Detroit Fairchest Ordinance, but that gives additional guidance as well. So the best practice is, a lot of this just tracks what you're required to do by the Fairchest Ordinance. Delay consideration of criminal. Okay, this is from the Office of General Counsel, but delay consideration of criminal history until you first made a decision whether the person is qualified based on income, credit, rental history. Obtain the record of the conviction, excluding arrest records, and avoid blanket prohibitions and consider rehabilitation efforts. Again, this is not only required by Detroit's Fairchest Ordinance, it is required. Like you could say, well, I'm not, I just have individual properties. I just have 5 rental homes or 10 rental homes. I'm not subject because I don't have multifamily dwelling units. Oh, you are subject to the Fair Housing Act. So you have to follow the same guidelines, even if you feel you're not within Detroit's ordinance. And then you have to carefully use guidance to come up with the best practices to use in making the final decision. So what people always ask, I'm not going to go into this part about it, is, okay, what policy should we use? I'm a housing provider, management company, what policy should I do? HUD OGC guidance has some. Here's one for public housing agencies. These are the factors that they use in deciding whether to rent to someone who has a criminal record. And these are the factors that they identify. If it's recommended by HUD, it's something that could be adopted. Of course, you could use, when it comes to, this one here is for, go to Detroit. You could use Detroit's. It's very good guidance, use it. Another one, that the Public Housing Agency has a practice for screening for criminal activity. And this has very, very similar to Detroit. If it's been recommended by HUD, it's something that you can use. And I can go through just part C, whether the applicant's offense bears a relationship to the safety and security of other residents, the level of violence, if any, for the offense for which the person has been convicted, the length of time since the conviction, the number of convictions that appear on an application or appear in the criminal record history, if the applicant is in recovery for addiction, whether they're under the influence of drugs or alcohol at the time of the offense. If someone has been in, drug addiction, alcohol, right? And they're recovering from it, they're going to have something on their record. It goes without saying, but the question is, where are they at now? We have a case where it was people that were in a drug and alcohol treatment program were all excluded from housing. Well, if you're being rehabilitated in a drug treatment program, or you're being treated for alcoholism, you are covered under the disability protections. You are within the protected class category of a disability. And the last part, consider any rehabilitation efforts that the applicant has undertaken since the time of conviction. You see how it's forcing and requiring to make individual determinations rather than a whole wide scale exclusion of people with any kind of a criminal history. One last thing, we'll get it here. This has guidance on, and I can provide this if you'd like it. We've talked a lot about criminal record at the decision whether to rent to someone at the application stage. Well, this is guidance when it comes to deciding whether to evict someone for criminal activity on the property. So you kind of want policy on both ends. And so this is guidance for public housing agencies and known as the federally assisted housing. If it's acceptable to be used in federally assisted public housing, it's acceptable to use by private housing or use in private housing or by private housing providers. And this gives some of the factors that you can look at here. Also, one last thing, I'll put this on our website. We do have sample letters where you can challenge the now for criminal history. And that's really very, very helpful. We also have a letter form that you can use to request an in-person meeting, because sometimes some people get real uncomfortable. They're not sure what to say, so they just kind of walk away, and you know, they're denied and they walk away because they just find the process too difficult. We can assist you with that. You can contact our office. You can access the information here, and we'll have kind of letters that you can use to get reconsidered and to have an in-person meeting. Very, very helpful. I go through some of the questions. Lisa, see if there's, I guess we should both go through this. After, I think maybe we've covered them. I thought there were additional questions. Sam, have we missed any questions? Sam?
Steve, the last couple that came on there
Your
are
answer?
not, can you hear me?
Yeah.
The last couple that are on there don't exactly have to do with criminal records, but they came in when you were talking. So good morning. I would like some more information regarding rental certification. And then the last one is, does discrimination of a person guidelines apply to Section 8 applications as well? I guess that last one maybe to answer.
Yeah, the rental certificate, we're going to cover that later within this program. The discrimination of person guidelines apply to Section 8 applicants too. I think it would be covered in Detroit, public benefit status. I don't know, Lisa would have more expertise on the specifics of Detroit's ordinance. Lisa, would public benefit status include Section 8?
Yes,
So it does cover it.
yes.
So if someone is turned down for Section 8, the issue we see with source of income or public benefit status is whether it requires a housing provider to participate in the Section 8 program or not. That's the question.
Yes, and so to be honest, some more research really needs to be done in regards to whether or not it requires a landlord to have a Section 8 voucher. So
Yeah,
I really
that's-
can't answer that question at this time.
Yes,
But we have received complaints in regards to that.
some ordinance specify and some don't. So it's, I think, I want to say currently, just at the state level, I think there's, because I'm working on this recently, 18 states that have source of income protection. 16 of them would provide protection for Section 8 voucher holders. In other words, they will, 16 of the 18 will require housing providers to accept Section 8 vouchers.
And Steve, there is one more question too that I think would be good to answer. So it's after a CREO's investigation, if they discover that the landlord did in fact violate the ordinance, what would the next steps be? I guess, right, from the, both from CREO's point of view and from the larger city of Detroit's point of view.
Right, so the next step, what happens is they receive a misdemeanor for violation, and it's taken to the 36th District Court. Most landlords want to comply. They don't want to go through having a misdemeanor and to go to court on that. So we haven't gotten to that point to where we had to issue or a citation or misdemeanor. Like I said, most landlords want to comply.
So your experience is when you bring it to the landlord's attention, they'll make steps to correct what they've done.
Right, if it's truly been a violation, yes.
Okay. Well, we're up on our break. Just by way of a brief introduction, Chui Karega is an attorney with more than 43 years. He's worked in the fields of civil rights, among others, for his entire legal career in life. He's outstanding cooperating attorney for the Fair Housing Center, has handled many significant cases for us. His introduction to civil rights began prior to birth, when Mississippi Jim Crow laws forced his mother to travel more than 100 miles, passing white hospitals en route to, including one in her own hometown, to give birth in a hospital that was a blacks only hospital. Sad. those days ever happened. Following a family move to Detroit, Chui attended Detroit Public Schools, Michigan State University, and the University of the State of New York Law School. Again, for more than 43 years, Chui, Ms. Karega tirelessly represented metropolitan Detroit families in lawsuits, including housing discrimination cases. That's not the half of what Chui's done. That's just the bio that he's provided. And he's an outstanding presenter, and we're really pleased and honored to have him with us this morning.
Good afternoon, everyone, or good morning. I guess it's still morning. I'm so grateful to have been extended the opportunity to speak with you this morning. Fair housing is critical. It is, you know, when you talk about food, clothing, and shelter, shelter includes housing. And without the shelter, the food, and the clothing, somehow missed the boat. So I'm happy to be here as one of your presenters this morning. And I want to talk to you about fair housing. But more importantly, right now, I want to talk to you about expungement. As Steve has indicated to you, I'm General Counsel for the Detroit branch NAACP. We're very, very actively involved in trying to make sure that all of the citizens, particularly those in our community, have the access to all of the opportunities that are available as a part of a citizenship in the United States. So many of us have run into situations where we stepped on a crack in the sidewalk and we got overcharged, and now we've got a criminal record. Well, the time has come. That process has affected so many people in Michigan, and now the Michigan legislature has said, okay, we're going to change things around now. We're going to let people expunge their criminal record so that they can get access to housing, they can get access to jobs, they can do what has to be done necessarily to help themselves. So let me talk to you first of all, what is an expungement? An expungement does not mean that a criminal conviction is erased forever. It simply means that a conviction is moved from the public record to a non-public record so that the record is still available to law enforcement, to the governor, to the FBI, et cetera, to transportation, what they call themselves, TSA. But here in Michigan now, we have the opportunity to have an unlimited number of misdemeanors expunged and up to 3 felonies expunged. There are some limitations, and I will go into those as time goes on.
We're going to, it's a lead into what Patrick has been discussing. And in some of the comments were asked about the inspections and getting landlords to, or housing homeowners, landlords basically, to make those needed repairs. And so we're going to have Samuel Fleming, Inspector Fleming is going to talk a little bit about that process. What is requirement for having properties inspected and repairs completed?
Good afternoon.
Hi, thank you for staying on. Appreciate
Yes, I'm happy to be here. Let me give all you guys a little bit of information about who I am. My name is Samuel Fleming. I work for Building Safety Engineering. I've been an employee of Building Safety Engineering approximately 25 years as an inspector, and also as a supervising inspector. Also, I have worked as a building inspector for actually inspecting permits. Also, annual inspector inspecting annual inspection. But currently, right now, I'm supervising inspector over residential property. And I did send you all some little information regarding what I do and what I actually supervise over. I'm supervising rental property and also residential. Now, residential property, as we define it, is property that is 3 units or more. Rental property is defined as 1 and 2 units. Okay. Now, the first thing any landlord should do when they have rental property is actually register the property immediately. That's before they rent it out, anything, get it registered. Second thing is actually get a rental inspection and by a third party if it's a 1 or 2 family residence, and can have an inspection by building safety engineering and environment if it's a 3 unit or more. Also get your lead inspection. You can get that lead inspection from a qualified lead inspector. You should contact the state of Michigan regarding a list of people you can hire to perform those lead inspections. Also, after that, once you pass both of those inspections, that lead inspection and also the rental inspection, you would get your certificate of compliance. You would then be in compliance with the property maintenance code as a landlord. The next thing you would do is they should maintain the property, make sure it doesn't slip back into any kind of blight or decaying state. Tenants also have a responsibility. The tenants actually maintain and actually keep the property clean. And it should be unlawful for anyone to occupy premise, cause anyone to occupy premise that is not maintained and habitable. That means including the tenant. They can't allow trash, debris, rubbish. They can't improperly park their vehicles or anything else. You know, they must keep the property up also themselves. They must do their due diligence. Tenants are also required to actually maintain property, especially if it's 1 or 2, basically 1 family resident. They should not allow vermin and I mean roaches and bed bugs. Technically, by law, the tenants is supposed to be responsible for bed bugs and roaches and so forth under 1 and 2 family residents, being that they don't own a person occupied. Once it's been exterminated and turned over to the tenant in a vermin state, they should maintain it that way. If they get
I think I've lost the sound. I don't know if Mr. Fleming, I think we. But we lost your sound for a minute. So I muted you.
Are there any question regarding what we do in building safety and how to actually put in a complaint? Because I know that usually is the biggest question with most people when I speak, is that they want to know how we get our complaints. You can call myself, and my number is 313-693-7125. Another number is at my desk, which is 313-224-7943. Either way, you can contact me by phone, or you can contact me at my emails. That's Flemings, FLEMINGS @DetroitMI.gov. And you know, I'd be happy to take care of you.
Did you want me to show the second one?
The complaint that we can deem as an emergency complaint, we usually answer those in 24 hours. Most times it's the same day. If you call before 12 o'clock, we will go out there the same day. If after 12 o'clock, then we'll be back out there within 24 hours. All the other complaints that come in, we answer those in 24 to 44 hours. I mean 24 to 48 hours. If you call us within 48 hours, we have someone out there under its normal circumstances of complaints. You know, that means you call us about the neighbor car, or you call us about neighbor property down the street, you know, having issues. We will come out within 48 hours. Within 2 days, we'll have it out there, and you will be able to get a inspection report. Anyone who makes a complaint, be it the tenant or the neighbor or whatever, they can contact us, and we will provide them with a copy of the complaint, the report, and they can get that free of charge. Anyone else, they would have to use FOIA, and they could pay for a copy of that inspection report.
So it's free of charge to the
tenants
person who makes the complaint?
A copy as opposed to anyone else without charges. Okay.
Does the landlord get a copy too?
What else? Let me see. Okay. Rental property. Let's define rental property. Rental property is currently occupied by a person, including immediate family, and an immediate family member is either a sibling, parent, grandparent, or child, or grandchild. which is written or agreement with the landlord with or without monetary compensation. That means you don't have to actually be compensated, long as it to actually be considered rental property. It can be rental property without compensation. If you go to some of the public housing special, you go to like Brewster Project, you'll find people over there that does not pay any rent. Their rent is zero, but they're still a tenant. They're entitled to get the same treatment, the same service the highest paying renter over there is paying. Okay. Also, rental property will in the future be occupied by a person, not a non-immediate family. That means if you plan on renting the property out in the future, we still consider that rental property. And you would have to register that as rental property at the time if you within the immediate future plan on renting that property out. Also, if it's been advertised or either rented in the last year, it's still considered as rental property. We still would want you to register and actually have your inspection because you probably would rent that property out within the next 12-month period. There are also issues when we come down to talking about rental property. Is some people say, well, you know, I live there and certain things that is not factual. We don't want people coming down here and actually trying to fudge the system saying that I live over here, but you know, I live over there too. We consider the property that you has on your license as your primary residence, any other property, we look at it as rental property. To me, this is normally how we view a property is 3 states. It's either owner occupied, rental, or is vacant. If it's not vacant, then it's going to fall into the other 2 categories, meaning occupied by the person who owns it, or it is under that rental property registration issues that I just spoke of. Property that is inspected by Section 8, unless in the Section 8 inspector specifically states that that property
I think he's breaking up. It's Fleming, so trying to reach it. Let me step in for just a second. Sorry about that. Mr. Fleming, we're having trouble hearing you. Mr. Fleming, we're not able to hear you right now. I don't think he knows he's muted. We can't hear you.
Sorry about that. My computer will mute itself at times. Let's go back over to lead. Lead inspection is for rental property is if you have it abated by different means, it's good for different time periods. Internal control lead and clearance is good for 1 year. Replacing additional lead clearance is needed if all lead plates are replaced. Enclosed lead clearance is good for 2 years. Encapsulation lead clearance is good for 5 years. And if you remove it, then it's good for permanent. It's permanent. Remove, you don't need another lead inspection. A lot of times, and most times, it's determined by the lead inspector, you know, how he designated that it was removed or either it passed. If you fail to actually comply any violation notice that we give you once we come out and perform an inspection, that you can be subject to fines. The list of fines that we give was on that little pamphlet and brochure. It can range from usually about $250 to look like $1 million, but $1,000. But we know that it's a different scale. I'm not gonna get off into that scale too much because it all depends on the offense and how many times you've been cited for that same offense. Okay.
Mr. Fleming, can you hear me okay?
When tickets are issued,
Can you hear me?
If they're not paid, then they are assessed against you, and we have people that will actually go forward and actually make sure that they get collected on.
Mr. Fleming, are you able to hear
Are there
me?
any questions regarding this? Because I know that's going to be the biggest topic of the questions.
Can you hear us? I don't think you can hear us. Can you hear us?
Are there any questions? Hello?
Yeah, we can't hear you. You can't hear us.
Okay. I'm not picking up anyone saying anything.
It's
Any questions regarding rental inspections or any of the criteria that we work under?
Mr. Fleming, I don't think you can hear us.
I can hear you, but
Oh,
I'm not hearing.
Okay, no, I'm going to read the questions to you.
Okay.
Let me ask you, okay. There's one question. I'm an attorney in the city of Detroit representing low-income tenants. Multiple tenants face major habitability issues, and there is no enforcement on the landlord to make these repairs. BSEED inspections do not result in repairs being made. Is there a way we can address these issues through court to hold landlords accountable?
Well, that's the first I've ever heard that BC do not get enforcement. We do get enforcement. We come out, like I stated before, we come out within 24 hours. If it's emergency for calling no heat and sewage, major issues, we out within 24 hours of that complaint. Once we get an emergency, we call that landlord that day and actually speak to that landlord regarding, we call that landlord that day and speak to that landlord regarding that emergency. And usually we try to get temporary heat within 24 hours. We make sure we get that done within 24 hours. If we fail to actually get that, then we will take that tenant out of that property and use our means and methods to actually put that tenant up in a hotel to make sure that tenant is not going to freeze to death actually during the winter time. Also, we use other means to actually take care of some of the issues that arise in some of these properties.
Should the attorney follow up directly with your office, or should they contact the city's attorney office? Where would you direct them on these kinds of cases?
Anytime an attorney is contacting the city, we always have them to contact the city attorneys. We do not interact with the attorneys because there's no reason for city inspectors to interact with attorneys, because attorneys is representing someone and it has basic agenda going on with whoever they represent, be it the landlord, be it the tenant, or whatever. And we do not get off into taking sides. A lot of times there was, yeah.
Just a second.
A lot of
I will
times
touch on some of these enforcement type issues when you've completed it. I will get into some of the things that they can do.
Yeah,
so
and now
they're not limited to dealing with your office, but at a minimum, I think you said that for a tenant will receive a free copy of your inspection.
Sure, they can. As soon as that inspection is done.
I personally had taken those inspections and attached them to court papers and given them to judges, and they're very well received, actually.
Right.
Judges, I find those inspections very persuasive evidence as to the condition of a property.
That's correct. We are the law enforcement agency for the city of Detroit, which is the state of Michigan, through home rule. We enforce the property maintenance code. which is actually a code promulgated from the state of Michigan Property Maintenance Code. So we enforce it. We are legally the law enforcement agency for property maintenance, for property in the city, existing property in the city.
Here's
Now,
a
whenever,
question. Yeah. Oh, I'm sorry. Go ahead. I don't.
whenever we enforcing this our property maintenance code, then it can arise to criminal misdemeanors, which is we adjudicate those over at 36th District Court. Those we do not take lightly, and there's a limited docket over there, so we just can't take everyone there for just minor things. You got to rise to basically we got to show that there's criminal intent there.
Well, here's a follow-up question. Do you track, or how do you all track landlords that continuously get bad inspections, especially those that are not maintaining units and then offering them to vulnerable folks, such as those experiencing homelessness? It would be helpful to have a list of landlords who do not maintain safe units or a place to submit reports on landlords whose units are now up to standard.
Right, we do have where we do often see, occasionally, sometimes often see landlord do have a bad practice of actually not taking care of their property, and those are the landlords that go to 36th District Court. So like I say, we don't take every landlord to 36th District Court because it's not necessary. Back in some years ago, when we did have that court system set up where everything went to 36th District, it overloaded the court system, and we was unable to get most of the cases there because it just wasn't feasible for, and it was just it just bogged everything down. That's why we came up with the Department of Administrative Hearing, which is a court system that could handle the load, and it's actually is full every day.
So you meet the capacity concerns with 36th District Court by going through by setting up the administrative process.
Well, Department Administrative Hearing is a court system that's set up to actually hear Detroit cases, not only not as opposed to 36th District hears based all the Wayne County cases. They hear a lot of cases. They hear everybody's cases, criminal cases, and everything else. These cases basically is property maintenance cases with the Department of Administrative Hearing. So you're not getting a lot of other stuff going on that takes up the time that we could have just for dealing with property maintenance.
Okay, someone asked, who's the inspector for District 3?
There's multiple inspectors for District 3. It depends on, you talking about Counsel District 3?
Apparently.
Okay, Counsel District 3. My guys would be Inspector Baum, Brian Baum, but there's other inspectors also cover District 3. The guys that I supervise would be Inspector Baum.
Okay, and then what's the approximate cost for the required inspections?
Inspections are done according to square footage, either 1 and 2 family. 1 and 2 family residence is usually about $150, which we doesn't necessarily perform those. That would be under the third party company. If you call in a complaint on a 1 family or 2 family residence, we usually go out and do that inspection. We give you a one-time fee of $134, but we do not complete the complete inspection at that time. We actually come back out and finish the inspection because we have a contract with the third party company to actually have them to do those inspections.
Thank you so much. There's how do you find out if your home has had a rental inspection?
They can go on the rental inspection, the map, and then actually look at it. Either they can contact building safety. We can give you that information, either provide you that information. Also, everyone who rents property out, they're supposed to obtain a certificate of compliance and post it in the property that they are renting.
So you should be asking the landlord.
The landlord is required by law to actually post that certificate of compliance.
So a lot of it, we run into problems, all of us, because we just don't know, right? So many things we just don't know. Do you have a list of lead inspectors? I think you kind of answered that.
Well, we don't do referral, and we doesn't keep that list of a lead inspector due to the fact that lead inspector have to be licensed. That license and is maintained by the state of Michigan. And a lot of times we don't know who is licensed or who license been suspended, or if they can actually perform inspections anymore. So we don't give anybody any referrals or anything because we don't know the status and state of that inspector's license.
But I believe the state of Michigan keeps those, the list of
That's
websites.
correct. That's
You
why
go
we
to the
refer them
Michigan
to the
website and get that.
Yes, because like I say, they can be good today and tomorrow they've been suspended for various reasons. If he did inspection and maybe they didn't like what they seen, they might suspend his license.
Some of the other questions getting into what happens, you know, when landlord's not making repairs and that, I'm gonna address that in my part. Where I can't keep people over 12:30. But thank you so much for sharing this information with us. The last part of the program, I'm gonna just share real quick on tenant rights and fraud protection. So what are some of the precautions for tenants in renting to avoid being a victim of rental fraud? I'm gonna go real quickly through it. First thing, make sure all property repairs are completed before you consider renting, and to see if the property, I will put this on our website. Make sure the property is properly registered up to code, that the landlord has a current certificate of compliance. One of the questions that came up in the Q&A was, how do you find out if the property has a certificate of compliance and the landlord has the certificate? You go online, the city of Detroit has a site for that. Second thing you need to do is to make sure you're dealing with the actual landlord. We've had reports, unfortunately, of people posing as landlords, even providing keys to the unit or to a home, and they don't even own it. Taking deposits, security deposit, first month's rent, and then you can't find them anymore. So go to BSNA online, and you can get information on who the registered owner of the property. You can go through the city Detroit assessor's website. You can also go through the Wayne County Register of Deeds. If you're dealing with a property management company, you can get that name, search through Michigan LARA site, Department of Labor. Another key thing, avoid using an oral lease. Leases can be oral. If it's less than a year, a month by month can be oral, but really you should be insisting on a written lease. It must comply with Michigan's Truth in Renting Act, and make sure, read closely what the lease says about utilities, late fees, other provisions. There are people that get charged for utilities or water bills when it's really not even their responsibility in the lease. Make sure you know what you're renting. If it's a half unit flat or whatever, who has a right to park their car in the garage? Or, you know, I've seen situations where landlords have everything in the garage, so you've rented the whole unit. It doesn't exempt out any of the property or any of the areas of the premises, and yet the landlord will not let you use the garage. So really make sure all of these things are done up front. Absolutely do not go into a property unless the repairs are done and it has a certificate of occupancy. And do not sign a lease, pay a deposit, or move in until the repairs have been made. It's the landlord's obligation under Michigan law to keep the units habitable and in reasonable repair with all health and safety requirements. Put repair requests in writing. The landlord's failure to make those repairs allows you to withhold rent and repair and deduct. Patrick Cooney mentioned, you know, that sometimes that results in eviction. It's not supposed to, but you have to be really, really careful before you withhold rent. Put it into an escrow deposit and get 2 or 3 estimates for the repair. Give the landlord notice of why you're withholding rent, that you put it into an account. It's a separate account away from your other funds, and that you will use those funds to make the repairs if the landlord doesn't do it in a week or 2 weeks or whatever time is reasonable. It's unlawful to the landlord to evict you because you made a complaint to the city concerning the repairs on the unit. That's a retaliatory eviction. Here's the requirement that the landlord keep the property habitable, the covenant, that all premises and common areas are fit for the use intended by the parties, to keep the premises in reasonable repair during the term of the lease, comply with all applicable health and safety laws and so forth, and that it's not in disrepair or violation of health or safety law. So that's what I do. If the city comes out, does an inspection, get a copy of that inspection, and that's something that courts and others will look at to see. It's not your opinion, it's not my opinion, it's what the city inspector found upon inspection of the premises. And so that's real important to know what these laws are. Domestic violence and stalking, it permits early termination of the lease. Michigan has specific requirements on that. The form has to be notarized. We have that available. There are other offices that have that available as too. You can contact us if you need help with filing that form. Basically, if someone is a victim of domestic violence, it allows them for an early lease termination. But you need to first file a police report or obtain a valid PPO. Violence Against Women's Act applies as well, but that's only if it's in Section 8 program or government funded or rental housing program. It doesn't apply to private housing. Another thing, we see issues with security deposits. With the security deposit, absolutely make sure that you get an inventory checklist and you complete it prior to moving in, and that you do the same thing, keep a copy of it, and you do your checklist when you move out. Security deposit is not allowed to be more than 1 1/2 times the monthly rent amount. Can also include a flat cleaning fee. I got an issue with that, but I'm told that's permitted. I have a problem with that. I think it conflicts with the third bullet here. Landlord may deduct for unpaid rent, late fees, utilities, if the utilities are the tenant's responsibilities and damages beyond the normal wear and tear. Landlord may not deduct for general cleaning and repainting. That's a Michigan Consumer Protection Act violation. You can recover $250 or actual damages. You have to be very careful paying attention to the security deposit timeline. One of the key factors is when you're moving out, you must provide the landlord in writing within 4 days after you move out a written confirmation of your new address. Then the landlord has 30 days to give you a claimed list of damages and whatever amounts the landlord wants to deduct. I believe it's 30 days. Wants to deduct from your security deposit. And then you have 7 days to provide in writing by US mail your objections to what the landlord is claiming. You've got to follow the procedure through it. If the tenant fails to do so, it can result in a landlord allowing to take your security deposits or portions of your security deposit. If a landlord doesn't follow it, then it can subject the landlord to twice the security deposit. But they're really strict requirements. That practical guide for landlord and tenants, it's on our website. That has information in it. It will have a whole checklist in order as to the procedures when it comes to security deposits. Make sure you follow that and do not lose your security deposit. Late fees is another issue. Late fees for rent payment must be reasonable, can't be a penalty. It has to bear relation to the actual cost. I looked at one case just recently. The late fees were, I don't know, $50, $75, or so many dollars per day. By the time I got done adding up the late fees, it totaled 28% of the rent. Late fees have to bear some relationship to the costs or expenses incurred by the landlord. How much cost or expenses incurred by a landlord in terms of a lease? Probably not very much if they get their rent 5 days late, 10 days late. But 28% is very, very high. The District of Columbia has an ordinance which caps late fees at 5%. I think that's a very good ordinance. There was proposed legislation in Michigan which would cap late fees at 10%. I think that's a little high, but when I see complaints coming in with 28% and even more, you realize that that's a real problem. So hopefully something will be done with late fees. Courts regularly allow $50 late fees. Sometimes some go as high as $100. I even think those are rather high, but we don't have good, clear law on this. We need it. Be really careful on your lease. You can negotiate the late fees before you sign the lease. Make sure they're reasonable. If you have a question about late fees, or if you want someone to review your lease before you sign it, we're happy to do so. Or, legal services will do so as well. Another thing, this is real important, interference with possessory interest, right? In order to legally evict, the landlord has to go through the eviction process. They can't just throw your stuff out. They can't threaten to throw your stuff out. you're not supposed to do that. They have to go through the court process. There are financial and other resources such as eviction program that can help. Here's an example. If the landlord cuts off your utilities, cuts off your water, changes the locks, that's an illegal lockout. And that can subject to damages for having done so. I want to thank everybody for participating. Thank you, everyone. Mr. Duncan, Lisa Kent, Chui, Mr. Cooney, Mr. Inspector Flemings for participating, making this program a success. Please join us for our next conference. It's going to be September 30th. I said October, I was wrong. That's a Saturday anyways. September 30th, we're going to cover disability rights. All the materials that you have seen presented, we will put it on our website. Have a way to do it so you can access it. For example, if you need help with expungements, it'll have the email address that Chui mentioned. I'll also put on there the information that the NAACP is looking for to start your process in order to enable you to obtain an expungement. All the other information as well will be there. The resource guide for home repairs will be there as well. I want to thank the city of Detroit and the Human Resources, Housing and Revitalization Department for their sponsorship of this program and their commitment to the city of Detroit, its residents, everybody within the city, and the hard work that they do. And again, if you haven't gotten, we will follow up with the questions that we haven't answered to make sure that everybody's question has been addressed. I want to thank you again. If we can be of any assistance and we can put you in contact with others that can provide assistance, please do not hesitate to reach out to us. That's what we're here to do. And I want to thank all of you so much. Again, we will post the videos in that, and I think Lesa may do it as well for the city of Detroit as well. So they'll be posted as well if there's something that you may have missed. I want to thank you all for participating and appreciate all the hard work that you're doing for the residents and that of city of Detroit. Lesa?
Yep. I just want to say thank you for having CREO be able to present about the Fair Chance, and please look for the website if there's any questions that anyone has, and reach out to our department. That's what we're here for.
I don't know if Mr. Warren wants to wrap us up.
Okay, I'm here. I was trying to get my mute button off. Yeah, on behalf of the city of Detroit, we really appreciate you, Steve, and doing this Fair Housing Conference webinar. I'm sure it was very informative to everyone that was on here. But anyways, yes, we want to thank you again and all the other folks who participated and share their information as well. We look forward to doing more things like this in the future. Hopefully we can make this an annual or biannual thing, because I know you mentioned we're going to do something in September 30th. So we're definitely, city is really glad to participate and present these informative information. So with that said, thank you everyone again for participating, and feel free, hopefully we'll get this information out there. I think we can put it on our website if anybody want additional information of some of the from some of the presenters and some of the questions.
We will send out Survey Monkey, so people, we try to keep it real short, but if anybody can share your comments, and especially we're interested in future topics that you think would be important for us to cover. So you can expect that. I know, just please take a few minutes to answer that as well. But yes, we are looking to do, again, the conference will be on disability rights. There's a lot of important information in that as well. And again, I will respond to, our team will respond to the questions. For example, someone sent an email to Mr. Fleming, we're unable to reach him. I will answer you back and give you his correct email address so you'll be able to reach him. But appreciate all the work that everybody does. And I know I learned some things today. I thought it was very helpful. Thank you so much.
All right.
Take care, everybody.